Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.
Welcome, everyone, to today's Savant Live webinar. My name is Dominic Perillo. I'm Director of Wealth Transfer at Savant. And today we're going to discuss navigating estate taxes in 2025. Our wealth transfer team focuses on planning for wealth transfer strategies in coordination with your overall estate plan, as well as trust and estate administration as well. And today I'm joined by Mike Sears of the wealth transfer team. Welcome, Mike.
Thank you, Dom. It's great to be here, and welcome to all of you who are joining us today on this call.
Glad to have you, Mike. We're going to get started and roll into our agenda. And we'll start out by giving everyone an overview of the estate and gift tax system, so you have some context behind where we're at, where we came from, and where we're headed. And then we'll get into some gifting techniques that could be appealing to everybody. And we'll start out with some simple methods and then cover some more advanced topics that involve trusts. And then want to speak briefly about how you can create some flexibility for future administration and trust that you might create by highlighting what's called a trust protector. And then no discussion with Mike and Dom would be complete without a refresher on the Secure Act, which impacts how IRA and qualified plan monies are distributed to your loved ones after you pass away. And then at the very end, we'll have some time for some questions. So you'll notice at the bottom of the screen, there should be a Q&A box. If there's a question that pops into your head, feel free to type your question into that box. And then again, at the end of the presentation, we'll try to cover as many questions as we have, time permitting. And this webinar is recorded. So everyone that's been registered for the webinar or is attending it live with us this afternoon will get a link to view the recording again. And that link should be available in a few days. So just keep your eyes out for that. It should come to your email address that you registered it for. So without further ado, Mike, if you can get us started on the estate and gift tax overview.
Yeah, thanks, Dom. Let's jump right in. When we first came up with this topic, was late last year, and there was just a lot of talk around estate taxes, and it was because there was this provision which we're gonna highlight and articulate within the Tax Cuts and Jobs Act that's going to sunset what is right now an all-time high exemption equivalent of the amount of wealth that you can transfer free of estate tax. And many of the provisions, we've got this entire tax law from 2017, the Tax Cuts and Jobs Act, that is set to expire at the end of this year. And there are many provisions in there. There's provisions regarding the child tax credit, qualified business income exclusion, there's rate reductions, assault limitation, et cetera. And some of those, for example, on the income tax side, maybe the rate's dropping from 39 to 37 or 35% to 33%. But on the estate tax side, and this is what generated all this buzz around estate taxes at the end of last year and running into this year, the exemption equivalent was virtually doubled in 2017, and so just a much greater consequence than some of these these other provisions within the Tax Cuts and Jobs Act. So we really felt the need to to get out to all of you and sort of talk about this. A lot of buzz out there. But we're very cognizant as well that a lot of these provisions are going to be, federal estate taxes exemption equivalent has risen to a level that a lot of those, that are joining us today are not going to be subject to federal estate tax. And so what we want to do is give you the good solid background, but then give you some everyday ideas and strategies, because a lot of these concepts, a lot of these opportunities, so to speak, they're applicable whether you're subject to federal estate tax or not. And then also it's just good to know the rules and that they are changing. So with that background, let's jump in a little bit and let's just get a fundamental understanding of what estate tax is. Estate tax is a death tax. It's a tax on the amount of wealth that you have when you pass away. And if we only had an estate tax, whether it's a federal estate tax or a state estate tax, then people that knew that they were going to pass away, they would simply gift assets away during lifetime. And so you need a gift tax as well as an estate tax if you want to really box someone in on the amount of wealth they have. And the federal tax system is the same way. Now, from 1916 to 1976, there were different sections of the tax code in the United States covering the estate tax side and the gift tax side, different credit amounts, different rates of tax that applied. And in 1976, they combined these two sections of the tax code, and they created for the first time what's called a unified credit. And so you'll hear that term used by us today, and it's one you'll want to be familiar with. The unified credit is the maximum amount of wealth that you can transfer during lifetime or at death and not be subject to federal transfer tax, either gift tax during lifetime or estate tax at death. In 1987, that exemption amount was $600,000 per person, and then the rates began at 37% and went to 55%. So it wasn't that long ago that the threshold was quite low, and a lot of family farmers, family business owners, and just individuals in general, because everything you own is subject to federal estate tax, life insurance, IRAs, real estate, business interests, et cetera. So it was easy to trip that wire, going to be subject to the tax. Now, the way the piggy bank works is if you want to transfer, say, $100,000 to a child or a grandchild, you can do that during lifetime. And then you can file a gift tax return, an IRS Form 709, and then use up some of that piggy bank of credit. So at death, instead of having a $600,000 exemption equivalent, if you used up $100,000 during lifetime, you'd have a $500,000. So the threshold before you were subject to tax would be reduced from the $600,000 down to the $500,000 level. So you can use this little piggy bank in different amounts during lifetime or at death. Now, there are a couple of exceptions that we want to talk about. There always is when we're talking about the law. The first is the exception. You can always transfer property between spouses. It's called the unlimited marital deduction. So during lifetime or at death, you can move property between to a spouse and unlimited amounts and not subject to the transfer tax system. Secondly, there's the charitable deduction. You can move assets to charity, again, unlimited in nature during lifetime at death, not subject to transfer tax. And then there's the annual exclusion. This one's super important. You can gift up to $19,000 to as many individuals as you want at each and every year, and it just recycles. Each year, you can gift your 5 children $19,000. That's $95,000 off of the balance sheet, not subject to tax later on. You can do that on December 31st. You can do it again on January 1st, and it just keeps recycling. So protecting that unified credit is often a good strategy. So you want to use those annual exclusions. If not, you file the gift tax return and eat into that little piggy bank that we all have. So those are some of the basic rules to go over. And this little slide that we have here, it shows what all the hub is about, so to speak. And that is the exemption equivalent, which was set at $5 million in 2012, was doubled in 2017. And you can see by the graph here, there's this huge opportunity potentially to gift out of your estate more today than you can, at the end of this year. And so everybody's, excited and planning for that. What I would note is on the federal side, if you leave all your assets to a surviving spouse, it's super important to pick up what's called the DSUE, D-S-U-E, deceased spouse unused exclusion. And this is done by an estate tax return of 706, where you acknowledge to the Department of Revenue that you're essentially porting your federal credit to your spouse. You didn't need it because you didn't use it by leaving assets to your children. So you're going to port that credit to a spouse. Now your spouse has their exemption, plus the one that you ported to them. That's called portability. It's also important to note that you got to always be careful about not only federal estate tax, but these pesky little states that are out there. There aren't very many left, but there are a handful, 17 of them in the United States that are in this game, and they have their own state estate tax structure, and they might get in the game a little bit. They have much lower exemptions in most cases, and the exemption is not portable from one spouse to another. So that's where, proper estate planning is super important. But you can see it on this slide here, sort of the opportunity that's out there and why there's so much talk around this topic right now. The next slide will, it kind of shows sort of the history of things a bit. And you'll see this is a moving target, which is really why it's so important to talk about this. You can see the Taxpayer Relief Act of 1997. That was a 10-year law that, we hadn't increased the unified credit from 1987. It had stayed at 600,000 all the way to 1997. And so the Taxpayer Relief Act was going to bump that up to $1 million. It was going to take 10 years to do that. The first year it went up 25,000, then another 25,000, and we were on that track. And along came Governor Bush, who became President Bush, and said, "I can do better than that," and enacted what is commonly called EGTRA in 2001. Immediately he said, "We're not going to wait the full 10 years. We're going to push this into a $1 million credit per person right away." Set it on a path towards repeal, and you can see another 10-year package. This was then subsequently knocked aside in 2012 when we had the Taxpayer Relief Act of that year. We used the same name, and we bumped it to $5 million per person for adjusted for inflation, and that was a new provision at that point in time. And then you can see the Tax Cuts and Jobs Act coming in 2017 and doubling that. A couple of things to learn from this is a moving target, as you can see. So we got to keep an eye on it. It wasn't that long ago we were proposing under the Build Back Better proposals and the American Families Plan, shrinking that unified credit to 3.5 million per person, or maybe 5 million. You never know what's going to happen. There have been times in our history where the estate tax rate has been as high as 77%. It's often been over 50%. It's a flat 40% right now, and it is a place to raise revenue to the U.S. Treasury. So always be cognizant that things can change. The other thing that you'll learn here is that the estate tax is tied to income tax changes in the law. And the income tax changes are tied to what's called budget reconciliation. So you may have heard that last week the House of Representatives passed a new, one of their new reconciliation provisions. They can do one a year. They plan on doing 2 this year. You can push 2 into 1 year under certain rules. But what they're hoping to do, they've said we're gonna allow tax relief for up to $4.5 trillion over the next 10 years, as long as we have $2 trillion in spending cuts. And this sort of gives us an idea of where things may be headed in the future. That 4.5 trillion threshold will be reduced dollar for dollar if they can't find 2 trillion in spending cuts down to the 1.5 trillion threshold. So it would drop it down to a $4 trillion tax package, if they can't find the spending cuts. Why is that important? Well, a couple of things. If we're wondering where estate taxes are going to go in the future, some of these provisions within the Tax Cuts and Jobs Act, the price tag over 10 years right now that's estimated on these provisions is right at about $4 trillion. So the reason they're trying to get the 4.5 trillion number is in there is there's other provisions, other priorities of the current administration, such as no tax on Social Security, no tax on tips, et cetera. And so they're trying to, removal of the SALT limitation, they're trying to provide some room in there. But even if they can't find the spending cuts, it's pretty likely that in large measure, the Tax Cuts and Jobs Act is going to get, everybody is betting that it is going to get extended because it fits within that reconciliation package. It'd be nice to get it for more than 10 years or 8 years. The Tax Cuts and Jobs Act was an 8-year program. Not likely, again, because you would need 60 votes in the Senate if you were going to try to push that through. And there's just never been 60 votes. So we constantly get caught in this paradigm where we're not able to get it accomplished. If you look at this slide here, I put this in here because it shows, it sort of ties down, could we get the 4.5 trillion total package over 10 years enacted it or not? And you can see the receipts going up. This is from the CBO. The receipt side has been fairly strong, going from 3.4 trillion to all the way up to 4.9 trillion last year. It's the spending side that's been sticky, and we've bumped off of our low there and just not been able to get that spending back down. However, if you take a mere 15% off that 6.72 number, you do find the $1 trillion and that's a yearly savings that would help augment that Tax Cuts and Jobs Act extension, which they're currently working on. So you can see that there's an opportunity there, and of course that's if we're talking a 10-year package with a $4 trillion cost at about 400 billion a year. Here there's $1 trillion in savings. Boy, you're 2.5 times the annual savings just right there. The second table there shows where the estate tax are embedded in of the total source of all receipts to the U.S. Treasury, and you can see income tax is the big accelerator here for revenue, and then payroll and corporate. Buried in that other is the estate tax side. How buried? Very, very buried. You can see that tiny little line there at the top. That's the revenue to the U.S. Treasury over the last 10 years from estate and gift tax. Not a lot of revenue, which could lead to hope that someday estate tax and gift tax gets carved out of the cycle, but it just doesn't seem very likely. It's not a strong revenue raiser, but estate tax is tied to income tax changes. Income tax changes are tied to the short-term solution of budget reconciliation and the fact that we can't get those full 60 votes. So that's sort of the background as to where we are today. A couple of important things. We put this slide in there because it shows a couple of things. The middle point there, I would bring it to everybody's attention. We know there's very little revenue that comes into the U.S. Treasury, little in the sense of the overall dollar amount, but only about 0.2% of the people in the United States pay estate tax. It affects very few people. Unfortunately, it does affect a lot of people, in what you would think would be, in sort of that middle modest estate, 10 million or less. You have to be careful when it comes to these taxes. They can really sneak up on you, and you need to be careful with them. It's important to note also that if we're going to raise revenue to the U.S. Treasury, it probably not estate tax, but watch capital gains tax, the loss of a step up in basis potentially in the future. That would create a lot of revenue to the U.S. Treasury if people weren't able to step up their assets at death. It would be broadly applied. There's been a lot of studies in this regard. So just different types of excise taxes or other types of taxes to raise revenue to the U.S. Treasury. So with that, Dom, why don't you just give us a little bit of insight, because we want to talk about, if you want to take advantage of this, it's not as easy as you think to take advantage of these higher credits, because you've got to eat the cupcake first, right, Dom?
Yeah. And I thank you, Mike, for your perspective and just insights on what might be in the minds of our lawmakers and how this works when it comes to affecting tax policy changes. But a question we frequently get is, okay, I know that I have this extra bonus exemption with the passage of the TCJA. I know that it might sunset, although now it looks like maybe there's a chance that it could get extended, right? There's nothing guaranteed. But how can I take advantage of this extra bonus exemption before there's a reduction potentially? And the IRS has answered that question. And I love this cupcake analogy that Jennifer Good of Alliance Bernstein used. I think this just creates a really nice visual in everyone's mind, because this is a pretty sort of hard concept to wrap your mind around sometimes. And I really appreciate this example. So when you think about the bonus exemption, the $13.99 million total in 2025 that Mike mentioned earlier, the IRS has told us that you have to eat the cupcake from the bottom up. So think about the entire cupcake as your $13.99 million exemption. The bottom of the cupcake that the IRS says we have to eat first before we can eat our icing is the $7 million basic exemption amount that we might revert back to in the event the Tax Cuts and Jobs Act does expire. And then that the frosting or the icing on top is really that additional increase or the bonus exemption that's available with the doubling inflation adjusted of the credit. So in order to really benefit from the bonus exemption, you first have to eat the bottom of the cupcake, the cake part, first, then you can eat your icing. What does that mean? It means you got to gift away from your estate at least $7 million or whatever that exemption is going to be when the Tax Cuts and Jobs Act does expire, or if there's not a renewal under the sunset provision. And then you can start using your icing. So there's a misconception. Okay, I know I've got the this high exemption. What if I make a $2 million gift? Am I gonna am I advantaged there? Well, the answer is no. The $2 million is going to come out of the cake part of the cupcake, not the icing. Hopefully that makes sense to everybody. You have to make significant gifts, and a lot of times that just doesn't really make sense for a lot of families and individuals. For some it does, but like Mike said, the estate tax doesn't affect very many people. Mike, do you have any thoughts on this?
Yeah, I mean, this is important to point out because as I said earlier, if you're 70 years and younger, probably anticipate that there's going to be another, if we extend the Tax Cuts and Jobs Act, there's going to be an expiration. And they used an 8-year time period the last time, which coincidentally puts you into a 4-year cycle of the executive branch in the White House. And so, expect this to come up again 8 or 10 years from now, maybe less. We might have this cupcake approach and this cliff if we just keep doing this. So it's something that we need to be aware of. A lot of people think, well, I'll just give $1 million away or something like that, and I'll take advantage of that. That's not going to be the case, and this cycle could repeat itself again in the future. So something to keep in mind.
Yes, absolutely. And then I know you mentioned this earlier too, Mike, in some of your introductory commentary, but there's a lot of focus on the federal estate tax that gets all of the media attention. Right, it's tied to these reconciliation bills and changes in tax policy, but don't forget about state-based estate tax. There's not very many states that have a state tax, but on this map we have up at the screen provided by the Tax Foundation, you can see the states that do have a state-based estate tax or inheritance tax. So that might require, as Mike mentioned earlier, a little bit of planning for those potentially lower exemptions. And quite often, if the state you live in does have a state-based estate tax, it more likely than not is going to be less than the federal estate tax exemption, sometimes much less. For example, the state of Massachusetts has a $2 million state estate tax exemption or threshold per individual. Illinois has a $4 million exemption. Maryland, a $5 million exemption. So it's all across the board. And only 2 states, I believe, Maryland and Hawaii, have that portability feature that Mike talked about, where you can transfer the unused credit. So keep that in mind. It's always good to dust off your estate plan, maybe do some advanced gifting, maybe restructure some things so you're not losing any of your state estate tax exemptions on the table. All right. And you might be listening to this and saying, boy, I don't think that I have a federal or state estate tax problem. Do I need to do anything? Like, what, I'm just not affected. Well, as Mike said earlier, even if you don't have an estate tax issue to wrestle, you still might want to consider gifting to your loved ones to assist them with, major life events, purchases of homes, weddings, that sort of thing. And I think it's important to understand the mechanics of making gifts and some different techniques. So we want to give you some insight into some simplistic gifting ideas, and then maybe talk about some more advanced ones for those that might be thinking about some estate tax minimization strategies. So at a basic level, and I know Mike, you mentioned this earlier, it's good to cover it again here, but each person, a donor, can gift or transfer $19,000 per year. And there's an inflation adjustment on that number. It looks different every year depending on what inflation is, to any individual donee. So if you're giving the gift, you can gift $19,000 to anybody you want. And that is considered the annual exclusion, does not require a gift tax filing, doesn't use up any of your lifetime exemptions. It's just sort of a freebie. So if you're a married couple, that means that you can gift $38,000 to any one individual over time. And anything over that exemption amount is considered a taxable gift. And that term is a little bit misleading because that doesn't necessarily mean that any taxes are due when the gifts are made beyond the annual exclusion amount. What it means is that if you gift more than the $19,000 number we just spoke about, you have to file a federal gift tax return. It's a form referred to as 709 or 709. And a lot of times what people do is they just elect to offset the taxable gift in excess of the annual exclusion with their lifetime exemption. So it just simply reduces the amount of the federal estate tax exemption available at your death. So no taxes are generally due if you go over that $19,000 number. It's a very important concept to keep in mind. Another technique, and this is sometimes overlooked, but if you make direct tuition gifts, right? You pay tuition for a child or grandchild, and you write the check directly to the university, or you pay medical expenses on behalf of a loved one. You're writing a check directly to the hospital, for example. There's actually no annual exclusion amount limitation. You can make unlimited gifts in any dollar amount if you're making those direct payments, right? So that's something to keep in mind. Another technique is funding 529 plans. 529 plans are tax advantaged college savings accounts. So you can put money in these accounts, they can grow tax free. And if the money is withdrawn and used for qualified education expenses, tuition, books, there's certain expenses you can use the money for, then that payment or withdrawal from the plan is tax free. Very popular. There's a special provision that allows you to front load 5 years of gifting without using up any of your estate tax exemption, even though you're going to be over the $19,000 annual limit. So you could put in 1 year into one 529 plan account for one of your loved ones, $95,000 currently. That would require the filing of a gift tax return. Again, no gift tax would technically be due. You can elect to use up your lifetime. Or actually, no, there's no exemption used at all. You just have to report the gift. And then the catch is that you can't make any other gifts to that beneficiary of that 529 plan without it being considered a taxable gift and using up some of your exemption, like we talked about earlier. Okay, pretty powerful. That's a lot of money you could put away for college in 1 year. You could speak with your financial advisor, run some projections, right? That might cover a significant amount of the tuition. And then the next point is, there's different ways that you can structure the gifts to your loved ones. You can keep it simple and just write a check to that donee, that person that's going to receive the gift. Or you could make that gift in trust, right? And there's pros and cons to each approach. The major downside of making outright gifts, especially to young people, is that if that person's a minor, they're not legally allowed to own property in their name. So usually there's a UTMA account, Uniform Transfer to Minors Act account established. Sometimes it's their parent or other legal guardian who holds on to those funds until they reach the age of majority. And it varies by state what that age is. It ranges from 18 to 25. So if you make gifts to minors, they'll eventually have access to that money, maybe at a young age, right? And that might be uncomfortable for you. So sometimes it's appealing to make gifts in trust to provide a little bit of asset protection. You can appoint a trustee in the trust document who can hold those funds and manage them for the beneficiary's benefit. And there's different provisions you can build in. You can keep it simple. There's a couple of examples down there, but something to follow up with your attorney or financial advisor on, just so you can see what's available. And Mike, I'm going to go to the next slide, but I want to get your take on anything you might want to add to those concepts.
Yeah, that's a great summary of all the different options, Dom. Thanks. I really like the crummy trust. I think that in sort of contemporary estate planning, there may be people joining us today. Maybe it's $1 million estate or something. The federal estate taxes are not an issue. Maybe the state estate tax are not an issue. And I'm increasingly seeing this planning sort of paradigm, but they want to do something. They're doing something for the children, but they're like, I want to skip a generation and I want to do something for the grandchildren. And maybe they embed it in their estate plan, but sometimes they just they want to earmark it and set it out there. And I think that the downside to the to an UTMA account is that they're going to receive those at a specific age that might still be too young and still lack the financial maturity to manage those assets, especially if the assets are put in at a young age and they grow dramatically over time. The same for the 2503C trust. They work great, they're easy, they're simple and straightforward. You place it in trust, but they have to have the right to take it out at age 21. If they don't, then it can stay in the trust longer. The crummy one is the one that I think just is increasing in popularity and probably works for a lot of people on this call. And that is, you just say, I'm going to create a trust. I'm going to move, maybe 25 or 50,000 there for a grandchild. I want it earmarked. It can be used for down payment on a home, maybe for for a reasonable car when they're 16, down payment on a home later, education, maybe a wedding. But there's some seed money there, something from grandma and grandpa or more senior generation earmarked. You can put your child, the grandchild's parent as trustee. So you've got a responsible party involved over the top of that, the actual parent, and then it stays in trust, for those defined purposes until age 30 or 35 or some age before they would receive it outright. It's really it's one of those techniques that's commonly used for estate tax avoidance, both federal and state, by the way. So if you're in one of those, states where you're fighting and wrestling, against these more onerous state estate tax provisions, you might think about it, but you might think about it even if you're not in a taxable state. Just, I just want to do something for grandkids, earmark it, have those things set. Now, the benefit is if you use the 529, it's earmarked for education, right? Otherwise, you have a penalty in there. So a lot more flexibility. The downside is you've got a tax return, potentially some tax at a trust rate. Although if you flush that income through, I think, Dom, to the beneficiary, hold the income down with the investments, then I think you would agree you'd flush that income back through to the beneficiary, to their return and off the return of the trust. Is that right?
Yeah, I agree with that. It gets into the provisions of the trust, and more often than not, we're seeing the crummy trusts put in place because you can have that extended asset protection feature and have some more customization around it. It's a little bit harder to administer. You have to issue crummy letters giving the beneficiary the notice that they can withdraw the contributions. Usually the withdrawal doesn't happen, right? But that's how those gifts can qualify for the annual exclusion. So yeah, thanks, Mike, for those practical points. We're seeing a lot of this with smaller dollar denomination gifts. Okay, so those are some simple gifting techniques, maybe not so simple. Hopefully those made sense to everybody, but what we consider simple. And then we turn the page to just give you a glimpse into some advanced gifting techniques that might be appealing or might be intriguing, or maybe you've heard some of these terms before. So we want to give you a primer on qualified personal residence trusts, or QPRTs is the acronym, grantor retained annuity trusts, or GRATs, charitable lead trusts, and spousal lifetime access trusts, or SLATs. You may have heard of some of these techniques in the media or in speaking with your financial advisor. So I want to make sure everybody has a foundational understanding of how these things work. This isn't the full spectrum of trusts and gifting techniques that are available, but these are some of the major ones that we tend to bring up in conversation for consideration. We have a note that if you have life insurance, right, it might be a good idea to evaluate whether an ILET or an irrevocable life insurance trust might make sense, especially if you're thinking about buying life insurance, to keep that life insurance policy death benefit out of your estate. Those were much more popular, Mike, when the estate tax exemption was 600,000, right? Like basically up until 1999, from your history lesson. But Mike, can you give the audience just some foundational background on how a qualified personal residence trust, or QPRT, works? I think it could be intriguing to some.
Sure. Yep, you bet. QPRTs are my favorite. I've long loved QPRTs. I have an affection for them. But I want to make this point before I jump into how this device works, that a lot of people that are in highly taxable estates are thinking, gosh, this exemption, I need to do something to make this huge gift before the expiration. Or again, if we have extension here in the next couple of weeks or next couple of months, and then it comes back to bite us 8 or 10 years from now, they're going to be thinking the same thing. But what I usually tell people is, for the first thing you want to do is, let's just say there's an expiration and we're down to, I don't know, $7.5 million per person. That's $15 million for a couple. The first analysis is, do you want more than $15 million to go to your family members? Is that, is that a goal of yours? If it is, then let's consider all of the options are out there. Some of the easiest are, first of all, there might be a charitable endeavor in there. So maybe you want, maybe you're gonna leave something to charity. And but again, if you get to the point where, like, with charity and with double the exemptions, if there's a spousal situation, I still want to leverage more before you jump to using, eating the frost, going through the cupcake as well as the frosting. Think about some of these devices, because they're going to get you frosting, okay, without regard to whether there's an expiration of the tax law. And I'm going to show you what I mean by that here in the QPRT. So here's an example. Somebody has $1 million home. They're going to create an irrevocable trust called a qualified personal residence trust. They're going to transfer, they're 65 years old. They're going to transfer the trust or the house into this trust, retain the right to use that house for 20 years. Okay, so they pay the taxes, they live in it, they pay all the bills, the upkeep, maintenance, etc. And after 20 years, it becomes the children's home. This could be a second home as well. This technique, one of the reasons it's my favorite, it's so common that in a revenue ruling, the IRS actually gives lawyers the prescribed form to make this work. Very safe, very low risk. And what happens with a QPRT is you move the $1 million residence in, because you're retaining the right to use it, the IRS calculates the gift at the time of transfer as a gift of not $1 million, but it's damaged. It's damaged fruit with 20 spots on it, one spot for each of the years that you're going to live in the house. And so the gift to the kids is only, pursuant to whatever the interest rates are at a given point in time, $171,700. So what happens is the house goes in at $1 million. It grows at 4 or 5, whatever percent that real estate's appreciating at in that particular market. It becomes worth $2.2 million. So what happens is you've given away a $2.2 million asset for a mere $171,000, so less than $200,000. So you picked up $2 million worth of free frosting, and you didn't even have to sweat out the Tax Cuts and Jobs Act expiration provisions. You didn't have to get into all of that detail. You just said, I'm going to do the QPRT. I'm going to live in the house anyway. You can sell the house, replace it with another house. You can sell the house and not replace it with a house. A lot of flexibility. As I said, the forms are out there. These things work great. And the savings are dramatically more, of course, if the value of the real estate is higher, or if the appreciation is more than the 4% annual growth rate that we assumed here. It's a fun little technique. You'll see it come back up in a minute. I don't want to spend too much time on it, but it's a nice way to get a little frosting, retain the right to use it. And a lot of times, again, family home or family vacation property up at the lake, you can keep this in the QPRT and keep a family home, perhaps a vacation property for many, many generations. Now, the caveat here is when you make the transfer in, it's going to be a transferred basis. You're not going to get the step up in basis. So you're swapping potentially a 40% estate tax savings for a 20% loss in additional capital gains tax. You're losing the basis adjustment there. So this is why it's it's super important and paramount that we consider all of the options that we have available to us when we're going down this path of estate tax avoidance. So that's my favorite, Dom. How about
That's
the GRAT?
why we saved it for you, Mike. I know you like QPRTs a lot, and I see it a lot with the vacation properties. It's a really convenient vehicle to transfer those cherished vacation properties or family lake homes to your loved ones. One more, I guess, caveat or red flag, and you're going to see this in the next example when it comes to grantor retained annuity trusts, is that you also have to survive the trust term. Right. So if you're sick, in the example, the donor, the person making the gift was 65. It's a 20-year QPRT. You'd have to make it beyond age 85 for the strategy to work. Otherwise, the value of that home is drawn back in to your estate. But like Mike said, it can be a really convenient, good thing, somewhat low risk as well. So what is a grantor retained annuity trust? This is another gifting technique. And I like to think about grantor retained annuity trusts, or GRATs, we call it a GRAT from here on out, as estate freeze techniques. So in Mike's example, right, the whole house was given to the trust. And at the end of the trust term, the entire house, the roof, walls, windows, and all, transferred to the remainder beneficiaries, usually the grantor's children or descendants. With a GRAT, what you're transferring is not the house, but the appreciation of the asset to the remainder beneficiary. So the way these work is you set up an irrevocable trust, and it's going to be set up for a term of years, and you receive an annuity payment back to you as the grantor. So you're gonna make a contribution. And then every year that this trust is in existence, you're going to get a portion of the principal contribution back to you in the form of a fixed annuity payment. And at the end of the trust term, whatever's left over, that will get transferred to the remainder beneficiaries. So in this example, there's a $3 million initial funding amount. And this is a 15-year term. A lot of times attorneys favor, and estate planning practitioners favor shorter trust terms, because again, you have to outlive the term of that trust interest for it to work. So you might see some shorter term ones, but the longer the trust term is, the more time there is for those assets to appreciate. And I think this is a good example just so you can visualize how these things work. So there's $3 million you contribute. You're getting a payment back to you every year. And at the end of the 15 years, whatever's remaining transfers to your beneficiaries. In this case, the remainder would, we estimated to be $1.2 million. So your kids or the remainder beneficiaries, whoever those individuals might be, get $600,000 each in this case because there's two beneficiaries. And you can structure these trusts to be what's referred to as zero gift GRATs. So the annuity payments are structured in a manner, again, according to IRS prescribed interest rates, as Mike mentioned earlier, to basically pay you back the entire initial trust principal funding value. And that's what makes the gift value a nominal amount, something close to zero. So it's a way to transfer potentially gift tax free future appreciation on your assets. And this can be powerful if you don't quite yet have an estate tax, but you want to, you don't want to necessarily commit to a larger gift. You might have an estate tax problem in the future. Well, how do we keep the value of our estate where it's at? Maybe a grantor retained annuity trust or a GRAT would make sense. You can transfer that appreciation, keep your estate value frozen. That makes sense. All right. So that's another popular one. And then, Mike, this is another one near and dear to your heart, the charitable lead trust. Can you run us through this example?
Sure. I think the reason I like this one so much is it acts just like the qualified personal residence trust that we described earlier, except in this case, instead of you transferring the residence, like the GRAT, you're picking up additional frosting, you're transferring assets with the remainder of assets dropping back down to your family members, children, or what have you. But in replace of you using the property, you have a charity that's getting those assets each and every year, that percent, that use of the property. So in this case here, you can see, just an example, we put $3 million in, paying a 5% payout for the term of the trust, which we can set the term however we want it. We set it at 20 years. So you're taking these assets, putting them in this charitable lead trust, then taking the 5% out, $150,000 a year. You can decide which charities get those assets. Your family can decide which charities get those assets. You can put them in a family foundation and segregate them. There's some rules around that. But again, it's earmarked for charity. So there's a big charitable component to it. The assets continue to grow and they leverage over time, just like the QPRT. And what happens is, if you follow the math through, we end up with a significant asset, in this case, $5.4 million being distributed to the next generation, and the value of the annuity payments was 1.8 million there. So that means the gift, the remainder interest, was 1.1. The calculation of the remainder interest, according to the IRS, is 1.1 million. But guess what? We got 5.4 million there to the heirs. We just picked up $4.3 million worth of frosting on our cupcake by doing this device. Not only that, but we've benefited charity along the way. We've got this super nice philanthropic endeavor that's cooking along. We're involving that other generation. And there's even a better opportunity here. If you do this during lifetime, you can actually create a lifetime charitable lead trust. You can do it at death if you want as well, to sort of hedge against the estate tax, but you can do it during lifetime and get an income tax deduction, which you then can wash against other taxable income, such as if you want to do a Roth conversion and move IRA money that's otherwise taxable into a non-taxable setting. So now you're washing the lifetime charitable deduction against that other income, and then you're still getting this leverage on the estate tax side of things. So kind of tricky, not for everybody. Doesn't have to be 3 million, could be 1 million or something like that, but a fun little technique. And again, the idea is there's a lot of opportunity out there when it comes to different devices, and you don't want to get, just gravitating towards one device, which is what a lot of people tend to do. They tend to think about the next one, Dom, and that's the SLAT. That's the one that everybody was talking about. Boy, I gotta have a SLAT, and how quick can I do that? So why don't you?
That's right. Yeah, and these, this term spousal lifetime access trust, or SLAT, this comes up in some of these transitionary years, right? When there might be an expiration or a new tax proposal that might pull those federal estate tax exemptions down from the current level. But the way these trusts work, and here this is an example of a married couple, is that each spouse could create a trust for the benefit of the other spouse. And the idea is that you take that entire cupcake, bottom and the icing or the frosting, and you contribute it to each trust. Because the idea is that you want to lock in your bonus exemption. So you're making a lifetime transfer to an irrevocable trust that benefits your spouse. And because of the way that trust is structured, that value isn't going to be included in either of the spouse's deaths, for their estates of death rather. So it's a way to sort of lock in your exemption. You're giving away the entire house, the entire cupcake. But again, to really get maximum horsepower, you want to use as much of your current exclusion or exemption as you can. Again, a lot of times the folks that are putting these together have estates, north of 25 million, 30 million, 40 million, right? And they know they're probably going to have an estate tax problem, regardless of what the exemptions are. If we go to stay where we're at, or we have a $7 million exemption. So it might make good sense to consider doing that. Again, not for everybody, but hopefully, you have a little bit more background in how these work and are familiar with the term. All right. And then Mike, what are some things that the audience might consider doing to provide for some flexibility for future trust administration? Because when these trusts are put in place, whether it be a gift trust or a crummy trust or a SLAT, right? A lot of times you're operating on things as you know them now.
Provisions. And these are you say might not be for everybody. This is one that's for everybody on the call to implement this flexibility. And so again, coming back down to a little bit closer to ground level, you got $1 million estate, maybe a couple of children, 2 children. You're going to establish trust for them because maybe you don't want those assets to just end up in in a situation where they're going to get expended improperly. So you're creating a trust for them. And you may have them as trustee of their own trust until they get to be age 40 or 45 or something like that. You might have a corporate trustee in there to manage it so that things just are done professionally and independently and there's no family conflict. And what a trust protector is it's somebody, it's like a Supreme Court that sits off to the side and has certain powers over the irrevocable trust that can be exercised in such a fashion that can optimize the trust from an income tax perspective, or to resolve disputes, or to interpret the trust, or even just to change provisions in the trust, administrative provisions, because something comes up. Maybe there's a grandchild that comes along that has special needs or something like that, and you need to tweak, you need to sew something different into the trust. I've been practicing long enough that I remember the days when irrevocable was irrevocable, and there are other rules out there. There are decanting possibilities or non-judicial settlement agreements that have popped up along the way. But back in the day, these things were super rigid and difficult to change. And trust protectors are really sort of the next evolution of that flexibility. I find that they're we see more and more attorneys drafting towards trust protectors. If you've got the right people that can serve in these different capacities, you can weave this into just about any estate plan. And again, it can save you a lot of expense, court expense. It could save you, the states are very different with respect to tax laws. We see that earlier on the estate tax side. On the income tax side, it can make a great deal of sense to change the situs, the birth certificate, so to speak, of a irrevocable trust to a different jurisdiction and potentially save significant income tax along the way. So this was one that's for everybody, and we wanted to make sure we threw this one in there as a strategy or an opportunity. If you haven't heard about it, ask your attorney next time you go in to review your estate plan. So now we're going to tackle Secure Act, and I challenge you. There's just so much with respect to the secure. There's a lot of strategy. There's a lot of people making major mistakes in their estate plan. So even though we're talking about, estate tax in 2025, we didn't want to leave this one out of the discussion today because there's just a lot of opportunity, a lot of strategy. And if you're really talking taxes and making things optimal from a tax perspective, you can't not leave, you can't leave this one out. So let's go over just the basics of it, if nothing else.
Yeah. And the fact of the matter is, most of you listening, and most people in this country have significant savings in IRA or 401k or other qualified tax deferred accounts. So everybody, I think, should have a good foundational knowledge of what this Secure Act is and what does that mean for your loved ones. And the big takeaway from Secure Act is that unless you're considered an eligible designated beneficiary, which I'll bring up on the next slide, there's essentially a 10-year time frame for how long you can keep that IRA account open after the death of the original owner as the beneficiary. And that means you got to pay income tax now over this 10-year period. Before the Secure Act was passed, it was more of a life expectancy approach, which could be 40, 50, 60 years, depending on how old you were when you actually inherited that IRA account from the owner. Okay, so who can sort of use the old rules of the stretch life expectancy as an eligible designated beneficiary? So in other words, these are the people that are not subject to the 10-year rule. Well, that's going to be a surviving spouse of the IRA owner. Surviving spouses have the most flexibility. A lot of times the surviving spouse just rolls the IRA account into their own name and treats it as if they've owned it forever, and their own required minimum distribution or RMD rules would apply. Another eligible designated beneficiary would be the IRA owner's minor children that have not reached the age of majority, which is 21 in the Secure Act. There's an opportunity to defer tax up until 21 before that 10-year clock starts ticking. Disabled and chronically ill individuals, and maybe there's some special needs planning opportunities there as well. And then, of course, last but not least, individuals not more than 10 years younger than the original IRA owner. That's typically a sibling, maybe a close friend, right? But you can't have that beneficiary being more than 10 years younger than you. And again, these would be the beneficiaries that qualify for the life expectancy stretch. We put this graphic together just to give everyone a sense of how to optimize or at least understand the implications of naming a particular beneficiary. And I know that the font is probably very small for you on screen, so we're going to blow it up for you and run through this. But perhaps for the unwary, make sure that you're filling out or thinking about your beneficiary designations. And why is this important again? You can't necessarily gift these accounts during your lifetime without incurring significant income tax. So sometimes they're sort of boxed in, and you want to make sure that you're at least setting things up properly to give your beneficiaries the most flexibility. So very common, we see this, the failure to name a beneficiary and the estate of the IRA owner becomes the default beneficiary. That's bad because now you've taken the 10-year potential opportunity or longer and made it into a 5-year window for tax deferral. Especially if that beneficiary, that IRA owner died before their RMD age. If you die after your RMD age, there's a ghost life expectancy rule that it can apply. But if you die after the age of 82, I believe, you're worse off than the 10-year rule would have resulted in. Again, we talked about spouses, right? That's usually the primary beneficiary for a married couple, but not always. Spouses have a lot of flexibility. They can treat the IRA as their own via spousal rollover. Sometimes it's important to, instead of paying those IRA monies outright to the spouse, to protect those assets in a trust for estate tax planning purposes, or maybe it's a blended family, second marriage type situation. So the key takeaway here is that talk to your estate planning attorney, talk to your financial advisor about what options might be available to you, because you have to structure these trusts properly with the right language. There's conduit language that you can include to allow optimal income tax deferral for that spousal trust beneficiary. So some things to watch out for there. Mike, do you have any thoughts on that?
Yeah, just very briefly, like you could go straight to the surviving spouse, right? You can always do the spousal rollover, but the family trust is a nice option, and it doesn't have to be all or nothing. Like you could drive 50% into the family trust, and that way if you go straight to the surviving spouse, there's no asset protection either if that surviving spouse is in an accident, or there's a tort claim, or maybe there's a remarriage, maybe there's for any number of reasons, or what have you. And so driving some of that into the family trust, you still can get deferral inside this trust equal to the single life expectancy table. So you still get strong income tax deferral on that, and you'll get that asset protection. So that's one of those things I just wanted to mention. It's worth for a lot of people, it's worth a second look. So all right, let's move on.
Last couple of points here. We covered this earlier. If you're leaving money in IRA to a non-spouse beneficiary, and that spouse doesn't qualify as an eligible designated beneficiary, it's going to be a 10-year rule. That's just the new rule under Secure Act, so keep that in mind. There might be an RMD in each of those, or a required minimum distribution in each of those 10 years based on the life expectancy of the beneficiary if you died after your RMD age. We got some clarification there from the IRS. Last couple points, then we'll take a few questions. We might be a little bit over our hour target, but I think that's okay. Again, you can leave assets or gift assets, name outright beneficiaries on your IRA. And as Mike said earlier, there's a lack of asset protection if you have an outright transfer. So a lot of times it's important for parents or grandparents to make sure that there's a trust in place to protect the funds for a young beneficiary who might have way different priorities at age 21 versus, age 35, right? And you can leave IRA assets in trust. But the key takeaway here is that you, again, want to make sure that your attorney is including the proper language to optimize income tax deferral. And a lot of times, if the disabled beneficiary, again, they're considered chronically ill or disabled, one of those eligible designated beneficiary categories, you can leave IRA assets maybe to a special needs trust or a disabled beneficiary trust and use that life expectancy payout, which is really important. Again, you want to work with a qualified attorney there if that's your situation, but another income tax deferral opportunity with asset protection features. And then the last thing, go ahead, Mike.
Again, increasingly there are a number of families where there's a disabled, somewhere in the chain of heirship. This is where you still get that stretch. The Secure Act compressed all of that stretch down to 10 years with limited exceptions other than the spousal rollover, et cetera. And here's where you can create a supplemental needs trust, run that IRA in there, and still get that huge income tax deferral. So when you look at the assets, those taxable IRA accounts make a great asset to run into a supplemental needs trust, and then use the other assets to the other children or family members. So this is where you can kind of dial that in a little bit. So I just wanted to bring that up.
Perfect.
Right, marching on.
And then the last one to round it out, we'll take some questions, are charitable beneficiaries. If you're philanthropic, charitably minded, IRA assets are great to leave to charitable organizations because charities don't pay income tax. And that means that you can leave more tax advantaged assets like trusts or brokerage accounts to your non-charitable beneficiaries, usually your family members, and just get a better income tax outcome. So don't forget that. IRAs are a great way to meet your charitable goals post death. All right, and then of course we talked about this a little bit. You have decisions to name outright beneficiaries or trust as the beneficiary. Work with your attorney, make sure that you're keeping the Secure Act in mind. There's some trade-offs, that might warrant a further discussion. All right. And we just want to thank everybody. Again, don't hesitate to put your questions in the chat. I don't think we're going to have time to answer every question, so we want to offer up a complimentary call with one of our financial advisors. If you want to have a consultation about your own financial planning, investment management, or gifting needs. And we'll take a few questions. Again, there's a Q&A box at the bottom of your screen. And let's look at one, Mike. Here's one. Go ahead.
Yeah. I got a couple of them. I love to reward the questions that come in, those that have stuck with us on really a complicated topic. So thank you. So one question came in. If your spouse passed away during this time period where we had the icing, so to speak, and you pick up that deceased spouse unused exclusion, do you get to carry that through even if there is a sunset? You do. And so that's super important, because if we have an extension, as we all hope we will have here, of the Tax Cuts and Jobs Act, especially on the estate tax side, potentially if there's a tragic event in there, you're going to pick up that higher exclusion and be able to apply it to your lower exclusion then. So that's kind of
so it's locked in, right? The number's locked in based on the date of death. That's a good one.
The direct tuition payment, there was a question there for grade in high schools. Yes, you can, as long as there's a regular faculty, a regular enrolled set of instructions and faculty, etc. Daycare is not going to qualify, but I think otherwise you'd be fine there.
Yep. SLATs, the spousal lifetime access trust, be wary of the reciprocal trust doctrine. We didn't get into a lot of the mechanics of those, just kind of introductory topic, but it's something you want to consult your attorney on. Make sure that you're creating them, the timing's correct, right? The terms are correct, just to avoid, the strategy being undone, so to speak. I thought that was a good question. And here's a really practical one we get, Mike. What if I am doing lifetime gifting, right? And maybe one of my children is a little bit older and I assisted with the down payment on a home, but I haven't yet made a similar gift to my other child. How can I account for that in my estate planning documents? Do you have any thoughts on that?
Yeah, it's very easy to. That's a great question. I'm glad that came up. There are many times where people will make gifts to grandkids, for example, and maybe one of the children has 2 children and another child has 3 or 1, and so there's this disproportionate amount of gifting. You can reference in your trust instrument a ledger that you keep and then just equalize at death. So it's very easy to do. Simple paragraph the attorney can insert in there, and then you're free to make these gifts, keep them on a ledger, and then you can say, look, I want to equalize it amongst, for example, my 2 children's lines of family, accomplishing equality there, and accounting for the fact that there may be 5 grandchildren on one line and 2 on the other, or something like that. So super easy to do that. So
perfect. And thank you, Mike, for your expertise as always. It's a pleasure working with you. And thank you, everyone, for your time and attention today. Great questions. Hopefully these concepts resonate with you. And we'd love to see you on the next webinar. If any time you're looking for more information about Savant and what we do, we invite you to check out our website at www.savantwealth.com to learn more, or schedule that 15-minute complimentary introductory call with one of our financial advisors. Thank you, everybody, and have a great day.
Thanks, everybody.
If you enjoyed this webinar, visit savantwealth.com/guides and download our complimentary guidebooks, checklists, and other useful financial resources.